Good morning, ladies and gentlemen. This is Kunal here. Today we are going to read about the legal services and the Lok Adalat. Let's start. In text question 16.3. Question 1. What are the advantages of a plea bargaining? Answer. Advantages of plea bargainings are: first, no uncertainty. Plea bargains take away the stress and the questions that surround a trial by jury. Second, court congestion. Cases are closed much quicker when plea are involved. This is a great for society because it declogs the court systems for more serious cases. Third, leniency. The person who has taken the plea often pleads guilty to a lesser charge than what they have normally been tried for. This ultimately translates into a lesser sentence for punishment. Guaranteed bail. From a prosecutor point of view, plea bargains for a godsend. They allow them to have an open and shut case that still always result in a prosecution. Prevention from trial. When a person takes a plea bargain, they no longer have to go through the trial. This means that other crimes that may have been committed and any damaging evidence will not be discovered. No maximum sentence. The biggest reason that many people take a plea bargain is the fact that they cannot receive the maximum sentencing for your crime. Aids other cases. Prosecutor will often roll other conditions into their plea agreement. Often it is said that the defendant will testify against a co-defendant, which may aid larger cases in a prosecution. Terminal questions. Question 1. Explain the main provision of Legal Service Authority Act 1987. In 1987, Legal Services Authorities Act was enacted that made drastic changes in the field of legal services. It is an act to continue legal services authorities to provide free and content legal services to the weaker section of the society to ensure that opportunities for securing justice are not denied to any citizen or by reason of economy or other disabilities. Every person who has to file or defend a case shall be entitled to legal services under this act if this person is: first, a member of a scheduled caste or a scheduled tribe; second, a victim of trafficking in human beings or beggar; third, a woman or a child; fourth, a mentally ill or otherwise disabled person; fifth, a person under circumstances of undeserved want, such as being a victim of mass disaster, ethnic violence, caste atrocity, flood, drought, earthquake, or industrial disaster; fifth, an industrial worker; sixth, in receipt of annual income less than rupees 9,000 or such other teacher or such other higher amount as may be described by the state government in the case is before a court other than the Supreme Court, and less than the rupee 12,000 or such other higher amounts as may be described by the central government if the case is before the Supreme Court. Question 2. Name the authorities which act constituted under the Legal Services Authority Act 1987. What are their functions? Answer. The authorities which are constituted under the Legal Services Authority Act 1987 are: first, the National Legal Service Authority; second, State Legal Service Authority; third, District Legal Service Authority; and fourth, Taluk Legal Service Committee. Functions: to provide legal services to persons who satisfy the criteria laid down in the Legal Services Authorities Act 1987. The conduct Lok Adalat at various levels. Third, to encourage the settlement of disputes by the means of negotiation, abbreviation, and conciliation. Fourth, to secure the legal rights of poor, downtrodden, and weaker section of the society. Fifth, to ensure that the operation of legal service system promotes justice on the basis of the equal opportunity. Sixth, to sensitize people about the aims and the objectives of the Legal Service Authorities Act 1987 and their legal rights. 7. Coordinating and monitoring the functions of state authorities, district authorities, Supreme Court Legal Service Committee, High Court Legal Services Committee, Taluk Legal Service Committees, and voluntary social service institution and other legal services organizations, and give general direction for the proper implementation of the legal services programs. Question number 3. The Lok Adalat system is beneficial for the poor section of the society. Explain. Lok Adalat are meant for the consolidated settlement of the disputes outside court, which is what most of our people like if the matter allows for this kind of settlement. There is a fear among large number of people about talking a dispute to the court, not just about delay in getting justice but also for financial reasons. In fact, one of the reasons for the formation of the Lok Adalat or People's Court is to provide fair and complicated justice to the financially deprived section of our society. Though government provides legal aids to poor, there is a fear of monetary loss during the time period, which is why most people prefer Lok Adalat. Lok Adalats can be decent supplements to the work of courts and could contribute to justice in a good way only if awareness is increased and people are encouraged to opt for them. For illiterates and poor, there are even more advantages of taking matters to Lok Adalats. Proceedings are conducted faster and is simple arrangements, and even in local languages, the Lok Adalat system is beneficial for the poor sections of the society. Question 4. Explain briefly the jurisdiction and award of Lok Adalat. Lok Adalats have been given statutory status under the Legal Services Authorities Act 1987. Under their said act, the decision made by the Lok Adalat is deemed to be decree of civil court and is final and binding all parties, and no appeal against such a award lies before any court of law. In the parties are not satisfied with the award of the Lok Adalat through, there is no provision for the appeal against such an award, but they are free to initiate litigation by approaching the court of appropriate jurisdiction by filing a case by following the required procedure in exercise of their rights to litigate. Question 5. What is the meaning of plea bargaining, and write down the advantages of plea bargaining. A plea bargaining is when prosecution and these defense lawyers come to an agreement on a certain case and defendant. The defendant agrees to plead guilty to charge in order to avoid a court trial. A plea bargaining can be defined as pre-trial negotiation between the accused and the prosecution, during which the accused agrees to plead guilty in exchange for certain concessions by the prosecution. Advantages of plea bargaining. The object of plea bargaining is to reduce the risk of the undesirable orders for the either side. Another reason for introducing the concept of plea bargaining, in fact, that most of the criminal courts are overburdened and hence unable to dispose of the cases of merits. Criminal trials can take days, weeks, months, and sometimes even years when guilty plea can be arranged in minutes. In other words, a plea bargaining is a deal offered by the prosecutor to induce the defendant to plead guilty. Match the following column. In text activities 16.1. Write down the names of the court functioning in your areas. Following are the names of the court following in your area. First, District Court of Ghaziabad. Second, Karkaduma Court. Third, District Court Noida. Question number 2. Find out some such persons who cannot afford to go to the court. Nirmala working as a housemaid. She is a very poor and a hard-working lady. Her husband is a driver. They have set two kids. They all are spending very poor life together. Thank you so much. I really appreciate that. Om Shanti, and kindly subscribe.